sometimes dissents really matter. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. Today, we're going to be talking about Justice Alito's dissent in the Department of State versus the AIDS Vaccine Advocacy Coalition, which is a case that was decided on March 5th, 2025, in the United States Supreme Court. And the opinion is actually issued as part of an order that is essentially vacating a stay. The principal opinion doesn't do much to explain why, but the dissenting opinion certainly does. Let's look in on it. This is one of the Doge cases, the cases that came about as a result of Elon Musk's work in trying to trim down the federal budget. It lays out what happened here. The district court in the D.C. area issued a temporary restraining order enjoining the government from enforcing directives pausing disbursements of foreign assistance funds. The respondents did not challenge the government's obligation to follow that order, and then the district court ordered the government to issue payments for a portion of the paused disbursements, those owed for work already completed before the issuance of the temporary restraining order. And he ordered it to happen by 11:59 on February 26th. Several hours before that deadline, the government filed this application to vacate the district court's order and requested an immediate administrative stay. So because the deadline was coming up pretty quickly, that's exactly what happened. The judge there, Judge Roberts, issued the stay. The application, though, for a vacator, in other words, to vacate the ruling, was denied, given that the deadline in the challenged order has now passed, and in light of the ongoing preliminary injunction proceedings, the district court should clarify what obligations the government must fulfill to ensure compliance with the TRO, with due regard for the feasibility of any compliance timelines. The order heretofore entered by the Chief Justice is vacated. What that means is that he's requiring the Department of State to pay out $2 billion in taxpayer funds for work that has already been completed. That's the important thing here. They're paying for work that's already been done. In other words, this money was budgeted to the USAID. The USAID sort of independently decided how to spend that money. Many taxpayers don't necessarily agree with that, but that's what they did. The government, in trying to stop the payment of that money, may have run afoul of the Administrative Procedure Act. But the Administrative Procedure Act does not provide a remedy, as we'll find here. This is the dissent when Justice Alito wrote this, with Justice Thomas, Justice Gorsuch, and Justice Kavanaugh. So 4 of the 9 are definitely siding with the president and with the Department of State in this case. And he starts it off with a question. And as I've mentioned before, the use of questions is a marvelous way to get your rhetorical point across. Does a single district court judge who likely lacks jurisdiction have the unchecked power to compel the government of the United States to pay out, and probably lose forever, $2 billion taxpayer dollars? The answer to that should be an emphatic no, but the majority says otherwise. I am stunned. You can tell that Justice Alito is pretty ticked off here. And there are good reasons for it that were completely glossed over in the original order above it, and which he makes plain here. In capsule form, this is what happened. Respondents are a group of American businesses and nonprofits that receive foreign assistance funds. Now, that alone is kind of skeevy, if you ask me. If we're going to give foreign aid, shouldn't we be giving it to the foreign countries that we're trying to aid, as opposed to giving it to non-governmental organizations in the United States and allowing them to peel off portions of that for salaries and expenses, and that's sort of feathering their own nest. I mean, that's what it appears to me to be. I don't know if that's true or not, but that's what it looks like, in my opinion. At any rate, they claimed the current administration's temporary pause of foreign assistance payments is unlawful. The TRO required the government to halt its funding pause. It based that decision on a finding that the respondents were likely to succeed in showing that the government violated the Administrative Procedure Act. The Administrative Procedure Act, by the way, is the way that most people challenge governmental regulations. but they don't usually challenge governmental actions in that manner. But here, because it relates to the removal of a benefit, you have a right to go through the APA if you are aggrieved by a government's administrative action. And that would essentially be where the offended parties here, the non-governmental entity that was getting these government funds, that's where they would go through the APA to get that restored. But essentially, the problem here was they were afraid they would lose it altogether. And the key thing from the first part of the opinion was they were being paid for work that had already been done prior to the order. And because the government was a little bit slower than what the judge thought they ought to be, he grew frustrated with the pace and he issued a second order requiring the government to pay out approximately $2 billion. The judge brushed aside the government's argument that sovereign immunity barred this enforcement order, and he took two steps that, unless corrected, would prevent any higher court from reviewing and possibly stopping the payments. First, he labeled the order as a non-appealable TRO. The fact is that most temporary restraining orders are non-appealable. They only last for a couple of days, and generally because of the time frame involved, they're not appealable. It takes usually many weeks to get it to a point where it can be appealed. In certain circumstances, however, they act as a permanent injunction because they demand action that simply you can't go back and fix. And that seems to be the situation that Justice Alito is talking about here. And second, he demanded that the money be paid within 36 hours. This left the government with little time to obtain the relief that it sought, and the government moved for a stay in the district court. The judge shrugged off the government's sovereign immunity arguments and ignored its request, and so they went to the United States Court of Appeals for the District of Columbia. But with only 4 hours to spare before the deadline, the D.C. Circuit dismissed the government's appeal because it took the district court's TRO label, in other words, unappealable, at face value. So Judge Alito says the Chief Justice issued an administrative stay. Unfortunately, they've now undone that, and as a result, the government must pay approximately $2 billion immediately, not because the law requires it, but because a just district court judge so ordered. As the nation's court, we have a duty to ensure that the power entrusted to federal judges by the Constitution is not abused. Today, the court fails to carry out that responsibility. And he says, at the very least, this should have been stayed. To start with, it's clear that the district court's enforcement order should be construed as an appealable preliminary injunction, not a mere TRO. A TRO, as the name suggests, is both temporary and it's used to restrain challenged conduct. But the order here, which commanded payment of a vast sum that in all likelihood can never be recovered, is in no sense temporary. Nor did the order restrain the government, it ordered affirmative action by the government, which gave the respondents a portion of the ultimate relief they were seeking. For these reasons, the Court of Appeals had jurisdiction to consider the government's appeal, and we have jurisdiction to review and summarily vacate the court's erroneous judgment. Even if the majority is unwilling to vacate the district court order, it should have at least stayed it. In considering whether to issue a stay, we look at a minimum whether the moving party is likely to prevail on the merits and whether the moving party is likely to suffer irreparable harm. In close cases, we also take into account other factors, like equitable considerations. Here, the government's shown a likelihood of success on the merits that sovereign immunity deprived the district court of jurisdiction. That's because sovereign immunity bars a suit by private parties seeking to impose liability which must be paid from public funds in the Treasury. And of course, that's exactly what they're doing. They're saying, you got to pay us this aid that, you said you were going to pay. But that's exactly what the district court ordered, and the restrained defendants shall pay all invoices, letters of credit drawdown requests on all contracts for work completed prior to the entry of the court's TRO on February 13th. Now, Judge Alito admits that, sovereign immunity can be waived, but the immunity must extend unambiguously to monetary claims. And the APA's waiver of sovereign immunity for such actions seeking relief other than money damages. That language, as we've explained, distinguishes between specific relief, which is permitted under the APA, and compensatory or substitute relief, which is not. And here the relief is much closer to a compensatory money judgment rather than an order for specific relief that might have been available in equity. Sovereign immunity thus appears to bar the sort of compensatory relief that the district court ordered here. And then he takes aim at a case cited by them, Bowen versus Massachusetts, which was a Medicaid case. He says Bowen simply recognized the basic reality of APA review that after a court sets aside an agency action, a natural consequence may be the release of funds to the plaintiff down the road. The district court, however, failed to mention, much less reckon with Bowen or Knudsen before plowing ahead with its $2 billion order, in order to take into account our previous suggestion that the proper remedy for an agency's recalcitrant failure to pay out money that was past due was to take them to the Federal Court of Claims. One might expect more from a federal court before it so blithely discards sovereign dignity. Finally, the government has a strong argument that the district court's order violates the principle that a federal court may not issue an equitable remedy that is more burdensome to the defendant than necessary to redress the plaintiff's injuries. The district court ordered the government to pay out all invoices and letters of credit. The district court offered no reason why universal relief to non-parties is appropriate here, and nobody has suggested that the government is unable to identify respondents allegedly owed funds and pay out only them. Below, the government-represented respondents seek roughly $250 million, still a large figure, but far less than the $2 billion ordered. The government has shown that it is likely to suffer irreparable harm if the district court's order is not stayed. We usually balance the equities on close cases, and this is not such a case, and our analysis could end there. But the potential consequences are, of course, serious. Any harm resulting from the failure to pay the amounts the law requires would have been diminished, if not eliminated, if the Court of Appeals had promptly decided the merits of the government's appeal, which it should not have dismissed. And if the government prevailed on its sovereign immunity arguments, neither respondents nor any of the recipients of their services would have suffered any unlawful consequences. Today, the court takes the most unfortunate misstep that rewards an act of judicial hubris and imposes a $2 billion penalty on American taxpayers. But the relief ordered is quite simply too extreme a response. A federal court has many tools to address a party's supposed nonfeasance. Self-aggrandizement of its jurisdiction is not one of them. It's a very powerful dissent, and it has been reported a great deal in the media. Will it ever amount to a hill of beans? Well, we'll have to wait and see. But it certainly does give you a window into what Justice Alito and Thomas and Gorsuch and Kavanaugh think about these particular issues. So that's what I have for you today. Thank you so much for watching. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.